table the night before the hearing takes place and a conversation they have with the attorney. There's a different set of dialogue that takes place when a person is in the company of a person who they trust, and the sense that there won't be an embarrassment felt if what one seeks as a sense of justice differs from what the world seeks as a sense of justice. When the kitchen table environment is switched to the formality and the legal arena of the court, many ethnic minority youth get the sense that there's nothing that's going to happen there that has my best interest at heart, because what happens in that environment is so alien to anything I'm familiar with. There isn't any real justice for me. I just sort of sit back and we'll see what happens. Now, when the culture of the attorney more closely matches the culture of the client, there is an ability to read the discomfort and the dishonesty of the client and have that client to deal with what the adult sees as a less than forthcoming perspective from the client. So if I'm a white attorney and I have a white client and I am trying to get the best possible outcome for my client, the closer my culture is to the clients, the more I'm able to intuitively recognize when I'm not getting all the information from my client. And it's what we do, and it's the art that's associated with the practice of law. There isn't any science that's associated with the law. It's very much an understanding of the law itself and then what parameters can be massaged to achieve an outcome. The greater the cultural difference between the adult practitioner and the client, there's not the same degree of understanding when the language is no longer being understood, and we're misled into believing that being able to speak English simultaneously equals an understanding of what's occurring. While I mentioned that if there is this sort of expanded requirement of an attorney to understand both English and Spanish and Hmong, and in places like the District of Columbia, Los Angeles, 126 dialects being spoken. What about the dialect of not understanding the cultural ways in which people express a manifestation of what they like to have occur as an outcome? So we can look at the formal cultures of, is this a boy or is this a girl? And is this a language that we share in common? But I'm not so sure that we recognize yet the requirements of understanding cultural nuances that allow a person to have a sense of, I have faith that this system will work for me, therefore I'll tell you what outcome I'd like to achieve. And in the sense of outcomes that we'd like to have achieved, there is unquestionably a sense of paternalism associated with an adult making a decision for you. And I'm not so sure that we don't need some of that paternalism of adults helping you achieve the correct decision. The lawyers ask, what is it that you'd like to have occur? But if we have a child who's lived in a community where they haven't gone to shopping malls and they haven't gone to restaurants, and they've not gone to a theater to see a film, and they've not seen a play, and they don't interact with anyone except within their neighborhoods, you've got this sort of sophisticated legal process taking place, and you're asking them, what would you like to have occur? It's like, I'd like to open my eyes and all this be gone. That's what I'd like to occur. I just would like to sort of blink and we would be having this conversation. So to say that I represent my client and I'm interested in what my client would like to do, the scope of options is so narrowly limited. I'd like to have an attorney or a group of attorneys that have children's interests at heart be a bit more paternalistic and say, you know, you keep saying to me you like popcorn and ice cream and pretzels, but there's really a wide menu of other stuff out there you can try, and if you don't mind, I'd like to share with you some other things that may be helpful to your diet. And once you know the full scope, imagine this, give me popcorn, give me pretzels, give me ice cream, and you describe a full menu of items which are available, not having experienced them, digested them, and eliminated them, and having them on different occasions with different groups of folks at different times, how still can you make a choice? So just because the attorney lays out an array of options that one might exercise, if those aren't a part of your being, they still represent a sort of reading, hearing perspective on these options without an experiential base. And the experiential base is what I think we anticipate when we describe the phrases knowing and intelligent waiting. Knowing and intelligent just isn't recognizing that a word exists. Intelligent isn't just a matter of awareness that options exist. Non-intelligent waivers anticipate that in a household or school environment where a person has grown up, the world in which you have swam has helped you practice those options. So parents who say to their children, "You've made a mistake, what should we do?" Those children who speak with attorneys have a very different response than parents who say to their children, "You've made a mistake and this is what I'm going to do to you." And many children who come to legal environments where dispositions and outcomes are associated with their participation in the process have not lived in environments where they engage in negotiated outcomes of things associated with their behavior. So we provide them with their critical stages of life development where they now are asked to be a participant in the process without having experience in that environment. That's at 5 minutes. I was not supposed to lose time for Gault. Gault got his own time. I was supposed to get my time close up. I don't know if I quite made that clear, but Gault got his own time. There's no way in the world I can give up, these 20 minutes with Gault. So that's why I asked you to do that.
I'm adding exactly.
So if Gault got his 10, and we'll get these few additional minutes. I would then very much suggest that without negating the child's right to make a decision, that maybe in instances where children don't have experiences in the sort of decisional process, that attorneys provide some additional structure in this regard. There are a couple of concerns with respect to specific language within Gault that I think may be useful, and we'll try to keep this within the time frame so that we can benefit from the questions which occur. A number of the areas that have been identified within the Gault decision suggest these kinds of outcomes which would be appropriate 40 years later. Representation that's individualized, developmental, and age appropriate, and free of racial, ethnic, gender, social, and economic bias. I don't think we can achieve it. I don't think we'll have an outcome that's going to be free of racial, ethnic, gender, social, and economic bias. I think what we do is we incorporate the decisional processes, recognizing those biases. There isn't any way that we're going to live in these United States of America and not deal with the biases that occur. The more homogeneous a country happens to be, and there are countries where most of the people who live in that country are of the same race and ethnicity, it's possible to have a conversation that doesn't have the same bias intent. But that will not occur in America. So I don't think we're going to work to achieve bias-free representation. We'd like to achieve representation with the understanding that bias exists. And if we say to an attorney, what you'd like to do is represent your child, and to the extent that you see bias, find a way to eliminate it, I think we're spinning our wheels in mud, but we should be working on more substantive issues. An example of the ways in which bias is a part of our culture that I think we can appreciate in short order. As a clinician, as a clinical psychologist, providing an assessment test to children, two questions I think help us appreciate this perspective. On this exam, one of the fairly regulated administered exams, a question is, what's the thing to do if you lose a ball that belongs to someone else? And the options are 2 points, 1 point, or 0 points. Well, you get the 2 points if you say, that ball belongs to someone else, it has value, and I have a responsibility to replace it. If you give that sort of sense that it has economic value, I replace it. Whether or not you have money, you get 2 points. But many urban children, all they do is, it's a lost ball, replace something else. That's a 0. Another question on the exam says, what's the thing to do if you find a wallet that belongs to someone else? Well, the 2-point response is you take it to a person of authority, and it's not just an adult, it's not just a parent or teacher, but the desire is that the child make a reference to law enforcement, sort of neutral adult figure. Unless you have an urban children you're going to find who say that if they discover a wallet, they will look for a police officer to return it to. But the sort of result of these